You logged into your dental portal to check a claim, and according to a class action lawsuit, the portal was tracking you anyway. Wyssta Services, Inc. runs the healthcare benefits portal for Delta Dental members. The complaint alleges it recorded members' online activity without their consent. This wasn't an outside attack. The lawsuit points at the portal's own operator, watching clicks that members believed were private. The complaint alleges that conduct violated the Federal Electronic Communications Privacy Act and the Illinois eavesdropping statute. If you held an account on that portal between January 23, 2021 and January 23, 2025, this case is about you. The plaintiff alleges he and other members were directly harmed. So what exactly was collected, and what did it cost? How did we get here, and what does it mean for everyone enrolled? On the morning of January 23, 2021, thousands of Delta Dental plan members likely logged on to their healthcare portal, unaware of the alleged digital intrusions unfolding beneath the surface. Wyssta, a key player in managing these portals, allegedly stepped beyond the bounds of privacy protocols by infringing on the Electronic Communications Privacy Act and the Illinois eavesdropping statute. The complaint highlights how Wyssta supposedly tracked the online activities of these members without their consent. This alleged intrusion into private digital spaces cast a shadow over the trust that users placed in the company to safeguard their private data. Imagine learning that your personal online interactions were being monitored without permission. Such a revelation naturally stirred palpable concern among the plan holders. According to the complaint, the impacts of this alleged breach were far from trivial, striking at the core of individual privacy rights. Although Wyssta denied any wrongdoing, the company agreed to a class action settlement to address these claims and move forward. However, the uncertainty lingers in the minds of many. What measures, if any, were in place to guard against such alleged breaches? The legal journey began with a swift response from Wyssta Services, Inc., a company whose footprint in the digital landscape was under intense scrutiny. Allegations had surfaced claiming violations of both the Federal Electronic Communications Privacy Act and the Illinois eavesdropping statute, suggesting that Wyssta was allegedly tracking the online activities of Delta Dental plan members. The period in question spanned from January 23, 2021 to January 23, 2025, according to the complaint. This alleged privacy intrusion drew the ire of plaintiffs who claimed harm had ensued from these actions, seeking accountability and resolution in the legal arena. With mounting pressure, Wyssta chose to pursue a settlement route, not as an admission of guilt, but as a tactical decision to alleviate the protracted nature of litigation. On August 20, 2026, the clock would tick down to the deadline for class members to either partake in the settlement or voice their objections. As part of this settlement, class members stood to receive a cash payment, albeit modest, reaching up to $16.50, depending on the claims filed. While a resolution seemed near, the final approval hearing scheduled for September 9, 2026, loomed large, bringing with it a mix of anticipation and skepticism. For the class members, was this resolution sufficient, or should heightened transparency be the future goal? Inside the complex machinery of a class action settlement, Wyssta Services, Inc. agreed to a formidable sum of $12.67 million to address allegations of federal and Illinois privacy law violations. This scandal stemmed from allegations that Wyssta, in managing the Delta Dental healthcare portal, violated the Federal Electronic Communications Privacy Act and the Illinois eavesdropping statute. Allegedly, they tracked users' online activities, capturing data without informed consent from the plan members spanning January 23, 2021 to January 23, 2025. The proceedings now benefit an extensive class of potential claimants, with settlement terms enabling these individuals to claim a cash payment, capped at $16.50, contingent on the eventual number of claims. Importantly, while no admission of wrongdoing was made by Wyssta, they have laid down a financial path toward resolution. Imagine the broad implications of this dispute. It's not just a question of compensation, but an exposition of accountability, or the lack thereof, in the digital age. As the claims process unfolds, class members have until August 20th, 2026 to submit objections or exclusions, with the final hearing set for September 9th, 2026, marking a critical juncture. But did this financial gesture satisfy those clamoring for greater oversight, or does it merely scratch the surface of a more significant problem? The plaintiff alleges harm to himself and other members, instigating broader fears amongst users reliant on digital portals. Imagine the sudden wave of uncertainty sweeping over individuals who discovered the potential misuse of their personal data. The suspicion that what was once believed safe wasn't entirely secure rippled through the digital community. Users of the Delta Dental Healthcare portal between January 23, 2021 and January 23, 2025 were specifically targeted to benefit from a class action settlement. The lawsuit claims Wyssta allegedly violated the Federal Electronic Communications Privacy Act and the Illinois eavesdropping statute by tracking users' online activities without consent. Such allegations were serious, prompting questions about how deeply personal data might have been scrutinized without knowledge. Though Wyssta has not admitted any wrongdoing, they agreed to a settlement of $12,670,284, ensuring members could receive up to $16.50 each based on claim numbers. But it wasn't just about the money, it was about safeguarding privacy. With a deadline for exclusion or objection set for August 20, 2026, and a final approval hearing on September 9, 2026, the resolution seemed orderly. Yet, it has raised larger questions. How widespread might such data tracking be across other healthcare portals? Is this an isolated incident or indicative of a more systemic issue?
Imagine logging onto your healthcare portal, assured of the privacy and security you expect from a trusted provider. Yet, unbeknownst to you, your activity is allegedly monitored, as claimed in a class action lawsuit against Wyssta Services, Inc. This lawsuit, known as a landmark case in federal and Illinois privacy law violations, caught the attention of many due to its implications on consumer digital rights. Wyssta is alleged to have contravened both the Federal Electronic Communications Privacy Act and the Illinois eavesdropping statute. Such actions, according to the complaint, tracked online activities of Delta Dental plan members without their explicit consent, a serious charge that threatens to undermine consumer trust in digital platforms. The plaintiff alleges harm was done to him and others due to these actions, prompting calls for accountability. In response, Wyssta has consented to a substantial settlement of $12,670,284, while maintaining no admission of wrongdoing. Against this backdrop, account holders from January 23, 2021 to January 23, 2025 await the oral hearing on September 9, 2026 with anticipation. Scheduled as the final step before settlement approval, it signifies a possible conclusion to a saga that questioned the privacy safeguards in the digital age. But will this hearing finally meet expectations, or leave more questions lingering in the air? As we navigate through an increasingly digital world, privacy concerns loom large. This concern is especially pertinent in the wake of a recent settlement involving Wyssta Services, Inc., a company that has agreed to a substantial class action payout of $12.67 million. This settlement is set to resolve claims that Wyssta violated federal and Illinois privacy laws, a claim that impacts their handling of data, particularly surrounding the Delta Dental Healthcare portal. The alleged violations revolve around potential breaches of the Federal Electronic Communications Privacy Act and the Illinois eavesdropping statute. The core issue? Wyssta allegedly tracked the online activity of Delta Dental plan members from January 23, 2021 to January 23, 2025, purportedly without their consent. The plaintiff asserts that such alleged actions by Wyssta led to harm for him and others in similar situations. Although Wyssta has not conceded any wrongdoing, they have agreed to the settlement, which includes cash payouts to affected class members, conditional on the number of claims filed. This chapter in the legal process won't close unceremoniously. It holds significant procedural milestones, including an exclusion and objection deadline set for August 20, 2026, and a final approval hearing slated for September 9, 2026. These decisions will unfold meticulously in a time that demands diligent safeguarding of our virtual information borders. In an era of burgeoning digital interconnectivity, are we doing enough to protect our digital boundaries? Imagine a courtroom humming with anticipation as the calendar flips to September 9th, 2026. The air is charged with a mix of hope and apprehension as the final approval hearing for a significant class action settlement convenes. Stakeholders, including attorneys, consumer advocates, and keen observers, lean forward, waiting for what could set a new precedent in the realm of digital privacy within healthcare. The events leading up to this day trace back to allegations swirling around Wyssta Services, Inc. They allegedly breached federal and Illinois privacy statutes, sparking anguish amongst Delta Dental Plan members due to unauthorized online activity tracking. These accusations claim violations of the Federal Electronic Communications Privacy Act and the Illinois eavesdropping statute, deeply troubling issues in an era of heightened digital scrutiny. The plaintiff alleges that these actions caused harm to individuals who engaged with the Delta Dental Healthcare portal during the specified period from January 23, 2021 to January 23, 2025. Without admitting any wrongdoing, Wyssta has agreed to fund a $12.67 million settlement, poised to disperse a cash payment of up to $16.50 per class member. As the August 20, 2026 deadline for exclusion from this result looms, many ponder the broader implications. What does this mean for the future of digital privacy in healthcare, and where do we go from here?